to navigate cross-border partnerships between the USA and India or Bangladesh. So today we'll be discussing some of the most important business and legal considerations that come into play when a US-based company partners with companies in India or Bangladesh. I'm really stoked about today's topic. More and more of my US-based clients are opting to work with talented business partners in India and Bangladesh in joint ventures, as well as in critical vendor, supplier, and service provider relationships. So I'm hoping that my practical experience with these matters will make this presentation that much more useful to you. Although I'll have to keep things at a pretty high level due to time constraints, we'll cover key areas like contract terms, dispute resolution, employment law, data privacy, and more. I'm especially excited because I expect that a large part of the audience today is based in India or Bangladesh, and I want to make sure that we're addressing these issues from both sides, recognizing the value that all regions bring to global business partnerships. Part 1. Contract terms in vendor-service relationships. Starting with contracts, one of the first things to keep in mind is how different expectations and norms are for contract terms between US-based businesses and those based in India and Bangladesh. For example, in the USA, contracts tend to be highly formalized with precise terms for every single scenario. If you're a US-based business contracting with other US-based businesses, you've probably had at least one experience where the vendor or supplier that you wanted to work with presents you with a 65-page monstrosity as their so-called standard form agreement from which they expect negotiations will proceed. Or maybe you yourself are one of those imposing those massive documents on others. The intentions here are rarely malicious. Things like service level agreements or SLAs clearly spell out a breadth of potential scenarios to ensure that expectations are clearly set in advance, with the hopes of avoiding future disputes. Presently, in India and Bangladesh, the landscape is evolving. When I first started working with Indian and Bangladeshi companies many years ago, if they presented any written agreement, it tended to be just a 1 or 2 page memorandum, pretty much just with the fundamentals relating to pricing. That was it. The idea was that if there was a disagreement or a misunderstanding, you would talk to each other and work it out. Now, this was often surprising to American business owners who, as I just mentioned, were used to having lawyers in their ears, encouraging them to take aggressive and litigious stances on everything. But things have changed. There's no question these days that Indian and Bangladeshi businesses are very sophisticated, and they will expect, present, and negotiate more structured contracts with their US counterparts, even if they might actually prefer a little bit less formality and a bit more flexibility in the relationship. A good practice is to ensure that both sides understand the need for clear and concise contract language, particularly when it comes to expectations around service delivery and payments. US-based companies, or really their lawyers, need to adapt and accommodate to the fact that there may not be a need to address every single contingency in the document. But consider including a clause requiring good faith negotiations among the business's lawyers or their owners, or formal mediation proceedings via teleconference in the event of a disagreement or ambiguities instead. Indian and Bangladeshi business leaders, please understand that the cultural norm in the US is for extensive due diligence, lengthy contracts, and highly structured terms, so it's absolutely nothing personal against you. You can find common ground by making sure that the contract addresses the following: a detailed, clear, unambiguous scope of work, payment terms that address currency exchange and payment timing, and that contemplate any nuances or quirks of local financial systems and banking practices. I'm actually surprised more parties in all countries don't negotiate to mitigate exchange rate risk. It is completely reasonable to include a clause that will cap your suffering in the event of unfavorable currency fluctuations when the agreement is denominated in a foreign currency. If a full service level agreement is too burdensome, the main contract should set expectations as to quality control and standards, as well as the appropriate delivery schedule. And if you're an Indian or Bangladeshi company, a force majeure clause can really help you. These are quite common with US companies, so your business partners won't be taken aback. A force majeure clause addresses events like civil unrest or natural disasters that could impact your ability to deliver services and will provide comfort and clarity that you are not in default if a force majeure event prevents you from fulfilling your contractual obligations. Of course, the other legal considerations I'll be discussing today may also require specific contractual provisions as well. Let's move on to part 2, dispute resolution. Dispute resolution is another critical area, and cross-border partnerships often run into issues over which country's laws will govern the contract and where any intractable disputes will be adjudicated and enforced. Let's consider a US company engaging a Bangladeshi vendor. The US party might prefer litigation in the US, but litigation in the US courts may not be practical for a Bangladeshi business, and vice versa. Whether these are rational concerns or not, both sides do have a tendency to be concerned about the reliability and fairness of the other country's legal framework and tend to wonder whether they'd actually be able to recover anything or enforce a decision on foreign soil in the event that they somehow manage to prevail. Also, I sometimes see US businesses that feel like they're big dogs, asserting their greater bargaining power to demand that the Indian or Bangladeshi business submit to jurisdiction in the US. But even if a court award is granted in the US, it may not be enforceable without going through the local courts in India or Bangladesh, adding significant delay and expense. So, what's the solution? Mandatory arbitration clauses often provide middle ground, offering a neutral forum for resolving disputes. For example, the Singapore International Arbitration Center, or SIAC, or the International Chamber of Commerce, or the ICC, are two popular choices for arbitration that should be agreeable to both parties. I personally see the ICC most often. But either way, arbitration tends to be faster and more effective than litigation, and more importantly, awards are generally enforceable in multiple jurisdictions, including the US, India, and Bangladesh. Part 3, cross-border hiring. This is a key point when US-based businesses engage workers in India and Bangladesh, especially in the growing sectors of IT and customer support. This can be done through direct hires, but more often I'm seeing it facilitated by a sourcing or staffing company based out of South Asia or another Southeast Asian country that connects the US-based business to highly skilled workers in the region. And yes, this can get convoluted very quickly. In the US, we're familiar with labor laws like the Fair Labor Standards Act, or the FLSA, which sets rules for minimum wage, overtime pay, and working hours, as well as various state-level worker compensation and unemployment insurance requirements. But here's where things get more complex. Let's take India as an example. In India, labor laws are much more extensive and protective in certain ways. For instance, the Payment of Gratuity Act requires employers to pay a gratuity to employees who have worked for 5 or more years when they leave the company. This applies even if those employees were engaged remotely for a US-based business. In India, companies must also contribute to the Employee Provident Fund and fulfill employee state insurance mandatory contribution requirements. These are things that US employers may not expect, but you need to be prepared to accommodate it. If you're working with a staffing company, they aren't going to let you bully them into deleting these contractual requirements because they're bound by law to comply, and so are you. In Bangladesh, companies have to comply with similar protective labor laws, like the Bangladesh Labor Act, which have provisions that cover termination payments, worker safety, and mandated holidays. So, if you're hiring workers in Bangladesh, you'll need to navigate those obligations carefully, especially your workplace safety requirements for manufacturing or other labor-intensive services. U.S. employers must not only comply with U.S. labor laws, but also respect the employment protections in the country where their workers are based. Failing to do so could lead to significant legal liabilities. Some of my clients across a surprisingly wide range of industries have had tremendous success engaging South and Southeast Asian workers, and it can be very cost effective even after you factor in the staffing agency's cut and the expense of having an employment lawyer review the terms. But you need to be mindful of the additional obligations implicated in this approach, and ignorance of the law is not going to be an excuse. And to my Indian and Bangladeshi entrepreneur friends who are watching this, there is still a lot of interest in the US about how collaborating with and engaging your skilled workforces can lead to cost savings and improved outcomes. And that interest is expanding far beyond the IT and customer service sectors where it was initially centered. I'm seeing this growing interest in the healthcare industry specifically. US HIPAA laws complicate this, but not insurmountably. So if you're watching this from India or Bangladesh, I perceive a potential business opportunity here. Part 4, data privacy considerations. So I just mentioned HIPAA, the US's healthcare privacy law, but that is only one small slice of the data privacy pie. When sharing sensitive information across borders, data privacy laws are a big concern. US-based businesses are subject to a hodgepodge of state-level privacy laws, typically including the California Consumer Privacy Act, or CCPA, which is considered to be the most stringent and comprehensive in most ways, or even the broader scope of the General Data Protection Regulation, or the GDPR, when dealing with European customers. But in India, for instance, we have the Personal Data Protection Bill, which is similar in many ways to GDPR. This bill regulates how companies can collect, store, and process personal data. It's particularly important to remember that companies based in India can only transfer data internationally under specific circumstances, such as having adequate security in place or obtaining explicit consent from the data subject. So US businesses working with Indian partners need to ensure that they're compliant with these data privacy rules, especially when sensitive customer or employee data is involved. This can get incredibly complicated very quickly when you combine the US's various state-level privacy laws, plus India's national level data protection bill, plus sector-specific American federal laws in industries like healthcare, finance, and education, and you need to figure out which applies when. In Bangladesh, similar concerns are emerging with new data protection laws taking shape. The Bangladesh Constitution provides the underlying legal framework for privacy rights relating to data protection, and in 2023, the government adopted a Cybersecurity Act, which superseded the prior Digital Security Act. Now, let me note that we are quickly exceeding the bounds of my expertise here. The main practice pointer I'd like to encourage, regardless of whether your business is based in the US, India, or Bangladesh, is that unless your lawyer advises you otherwise, your company's best bet is usually going to be to comply with the most restrictive applicable privacy laws, even if foreign laws are more stringent than your domestic ones. You need to be particularly mindful when sensitive personal information, like health information or financial data, is being shared across borders. Work with an expert to ensure all applicable consents are obtained and that you're meeting technical and procedural security requirements for data storage and handling. This will all be memorialized in a cross-border data processing agreement, and I'd encourage you to retain a lawyer with privacy law expertise to help ensure that it's sufficient. Part 5, intellectual property considerations. So let's move on to intellectual property considerations. Intellectual property protection is crucial in cross-border partnerships. US-based companies are used to strong IP protections, where trademarks, patents, and copyrights are vigorously enforced. There's a perception in the United States that although India and Bangladesh do have IP laws in place, enforcement can sometimes be less stringent. This often causes US business owners a fair amount of trepidation, and I'd suggest to you that an ability and willingness on the part of business owners based in India or Bangladesh to take measures to reassure their US customer, client, or business partner that their intellectual property will be secure could actually be a way for you to distinguish yourself from your competitors in the Americans' eyes. Most specifically, in my own legal practice, The area in which I've actually seen protracted disputes arise is when a US company is developing software with an Indian or Bangladesh service provider, but the original agreement did not adequately spell out who owned the resulting IP. And let me note, I was not involved in the drafting or negotiation process of any of those awful original contracts. Now, I suggested earlier that US businesses should be prepared to back down a little from their 100-page mega agreements because that's not really how Indian and Bangladeshi companies prefer to do business. But the flip side of that is I'd encourage Indian and Bangladeshi companies to work with their American partners and concede that this is part of the contract that really should be thoroughly detailed. If both the American entity and the Indian or Bangladeshi entity expects that they are going to own the underlying source code when the project is complete, but the agreement itself is ambiguous on this fact, that is a recipe for a protracted legal dispute that can end up costing both parties almost as much as the code itself is worth. Finally, I'd like to add that Indian and Bangladeshi companies looking to enter the US market should also make sure that their trademarks and patents are registered in the US to ensure that they're protected when they scale internationally. Part 6, Tax Considerations. So finally, I want to quickly flag a couple of tax considerations that you should be thinking about when you engage in cross-border business relationships. Let me preface this by making it crystal clear that I am not an international tax attorney, and indeed, I no longer do a meaningful amount of tax law work at all at this point in my career. It would be prudent to speak with a lawyer specializing in international taxation issues regardless, but this is especially true if you will be doing a significant amount of cross-border business or your margins are very narrow. To highlight just a few issues. Understanding double taxation agreements. So happily, there are tax treaties between the US, India, and Bangladesh that help prevent double taxation, but it's still important for both sides to understand how income generated from cross-border partnerships will be taxed, by which governmental entity and when. Withholding tax. For a US company, you'll need to consider withholding tax on any payments you make to an Indian or Bangladeshi company for services. In India, this withholding tax can be as high as 10%, so it's essential to factor this into your cost structure when budgeting for overseas partnerships. US, Indian, and Bangladeshi tax authorities all have different rules on handling withholding tax payments relating to royalties, dividends, services, and more. So needless to say, it's important you understand when and what amount of tax payments is due to avoid sometimes significant fees, penalties, and excise taxes. Transfer pricing. Next, consider transfer pricing, which refers to the pricing of goods, services, and intellectual property exchanged between related entities across borders. Both the US and countries like India and Bangladesh have strict transfer pricing regulations to prevent profit shifting and ensure that transactions are conducted at an arm's length price. This means that prices set for goods or services between related entities must be comparable to what would be charged between unrelated parties. Failure to comply with these rules can result in significant tax penalties, making it essential for businesses to ensure that their transfer pricing policies are well documented and compliant with local regulations. Permanent establishment risk. US businesses should be cautious about the nature and extent of their activities in India or Bangladesh, unintentionally creating a permanent establishment, which could subject you to local taxation on business income. And conversely, Indian and Bangladeshi businesses should be aware of how their activities in the US might trigger local tax obligations. Under most US states' law, if you're doing business within the state's borders, and what doing business means is typically defined by statute and tends to be quite broad, you will typically be required to register your business as a foreign entity with each such state's Secretary of State, and you may have additional tax obligations. And finally, tax incentives. So one more tax consideration, this one's a positive note. Both Indian and Bangladesh offer tax incentives to foreign businesses, particularly in sectors like IT and manufacturing. For example, Bangladesh has special economic zones, or SEZs, with tax holidays for businesses setting up operations there. U.S. businesses should explore these incentives as part of their long-term strategy. Part 7, additional considerations. So very quickly before we wrap this up, I'd also like to remind all parties to bear in mind cultural sensitivities, local regulations, and supply chain management. So for cultural sensitivities in business, I've mentioned this throughout this presentation, but it's critical to remember that the way we negotiate deals in the US may differ greatly from how it's done in India or Bangladesh. Understanding these cultural differences and adapting to them will go a long way in building trust. A little effort to understand local business etiquette, communication styles, and appropriate negotiation tactics can go a long way. Regulatory considerations. So on the regulatory front, remember that each country has its own regulatory frameworks. For example, the FDA in the US for food, drug, and medical device products, or the Bureau of Indian Standards for consumer products in India. So if you're a US company selling consumer goods in India, you need to ensure that your products comply with BIS regulations, just as a company in Bangladesh manufacturing medical devices for export into the US will need to meet the quality standards set by and receive clearance from the FDA. Supply chain management. Finally, if you're a US business sourcing goods from India and Bangladesh, you should discuss local supply chain risks with your in-country business partners. This means everything from doing your diligence as to whether labor and sourcing practices align with the norms and standards that your US customer base expects, to whether local conditions and availability will suffice to ensure reliable delivery. Really, these are considerations that you need to be asking of any supplier, whether they're based in the US or abroad. But they're that much more important given the international distance and the shipping, customs, and other logistical hurdles that you'll confront when moving goods across borders. I hope that you're convinced that cross-border partnerships between the US, India, and Bangladesh present amazing opportunities, but they require careful navigation of legal, cultural, and regulatory considerations. By understanding and respecting the different perspectives and obligations in each country, we can ensure that these partnerships are successful for all parties involved. Regardless of the country in which you or your business is headquartered, let me know in the comments what questions you have about cross-border partnerships or any areas in which you'd like me to do a deep dive video in the future.